Welcome to the lesson on the regulatory tension between investment treaties and host states' regulatory policy. As usual, the learning materials for this topic can be found in the description below the video, in order of appearance. Investment treaties, particularly bilateral investment treaties, BITs, and investment chapters in trade agreements, have become one of the most influential instruments shaping the regulatory landscape of developing countries. Rudolf Dolzer argues that by their very nature, such treaties reduce the scope of state sovereignty, since they limit the ability of governments to subject foreign investors to domestic legal and administrative systems. While this limitation constrains state autonomy, it also provides clarity by defining the respective rights and obligations of both parties. For investors, who face numerous risks when committing capital abroad, these clear boundaries are safeguarding features that create predictability and stability, which are vital for encouraging foreign direct investment, FDI. Simon Lester and Brian Mercurio argue that despite these benefits, investment treaties have long been criticized for narrowing the policy space, or, in other words, constraining the right to regulate available to host states. As became evident in the case of Técnicas Medioambientales Tecmed and United Mexican States, BITs were driven by investor fears of direct or indirect expropriation. Direct expropriation occurs when a government formally seizes an investor's assets, whereas indirect expropriation refers to regulatory or administrative measures that effectively deprive the investor of the use or value of their property, without formal transfer of the latter. Because the standard for indirect expropriation is based on effect rather than intent, governments may find that even legitimate public interest regulations can be interpreted as expropriatory. This uncertainty has fueled extensive arbitration claims, creating a tension between protecting investors and preserving governments' ability to regulate in the public interest. In recent years, the scope of disputes has broadened significantly, extending into areas such as environmental protection, taxation, and public health. This expansion has heightened anxieties in developing countries, where pressing social and environmental issues often require robust regulation. According to Lester and Mercurio, particularly contentious have been disputes in industries like mining, pharmaceuticals, and tobacco, sectors that are both lucrative for foreign investors and sensitive for domestic regulation. Arbitral tribunals have not always shown deference to these policy imperatives, and inconsistent interpretations of similar treaty provisions have cast doubt on the legitimacy of the system. Susan Franck argues that the fact that decisions on public issues with wide social and economic consequences are made in private by different arbitral panels, often yielding conflicting results, has only deepened this sense of unease. Case law illustrates these tensions. In Compañiá del Desarrollo de Santa Elena, arbitrators ruled that even environmental measures, no matter how beneficial to society, required compensation if they amounted to expropriation. This position underscored the principle that investor protection prevails even against laudable public policy objectives. Similarly, in ADF Group and United States, the tribunal emphasized that its jurisdiction did not extend to evaluating the domestic legality of U.S. measures, but only to their consistency with treaty obligations. Such reasoning highlights how arbitral tribunals often prioritize investor rights and corporate interests over democratic policymaking and broader governance considerations. A striking example of this dynamic is the case of Philip Morris Asia and Australia. The tobacco giant challenged Australia's Tobacco Plain Packaging Act 2011, claiming it violated protections under the Hong Kong-Australia BIT by depriving it of intellectual property and goodwill. The law in question required standardized, logo-free cigarette packaging, aimed at reducing smoking rates. Although the tribunal dismissed the case on jurisdictional grounds, largely due to procedural defects, the proceedings revealed how investment treaties can be used to contest public health regulations of major social significance. For developing countries, where regulatory capacity and resources are limited, the mere threat of such arbitration can create a regulatory chilling effect, discouraging governments from enacting progressive policies. In conclusion, while investment treaties attract much-needed FDI, by reassuring investors of legal stability, they also restrict the regulatory freedom of developing states. The inconsistency of arbitral rulings and the tendency to prioritize compensation over public policy amplify concerns about accountability. In sum, while investment treaties attract foreign direct investment, by offering investors stability and enforceable protections, they also narrow the regulatory space of host states, particularly developing countries. The arbitral system's inconsistency and its tendency to privilege compensation over public policy raise concerns about fairness and democratic accountability. Case studies demonstrate both the risks of regulatory chill and the need for careful treaty design. For developing countries, the central challenge lies in finding a balance, designing treaties that safeguard investor confidence while preserving the sovereign right to regulate in pursuit of environmental protection, public health, and sustainable development. Thus, balancing investor protection with regulatory autonomy remains one of the most pressing challenges in international economic law. Thank you for your attention to this lesson. To learn more about international trade, take a look at some of our other dedicated videos. We hope this lesson was helpful to you, and we are looking forward to seeing you again soon.